Good morning, everyone. So glad to be here. I've been introduced. I'm an arbitrator. I'm a lawyer. I don't know my audience, so I think it's easier if we start by. I've been asked. What's Adedumola? Yeah. Asked earlier on if any one of you is an arbitrator. I think my question to you is, how many lawyers do we have here?
Everybody is a lawyer.
So we don't have anybody that's not a lawyer. Online, is that the same? So we're all lawyers. We always think that every arbitrator should be a lawyer. That's not true. You don't need to be a lawyer to be an arbitrator. You could be a surveyor. You could be a medical doctor. The good thing about arbitration is that once you go through the course, you basically wear a hat of being someone that can listen to disputes and resolve. So strict rules of evidence does not apply. So you can imagine a medical doctor, there's a dispute between a patient and a hospital, and they're looking for someone to resolve that dispute. What do you think? If they come to Mrs. Ali as a lawyer, and there's a Dr. Patel or Dr. Tola that's an arbitrator and also a medical doctor, who do you think they will go to resolve that dispute? It will be the medical doctor. The reason being, he's qualified to be not only a medical doctor that would understand the issues, but also he actually has gone through either the courses to be an arbitrator. So that's why arbitration has really taken its place in the business world, because anybody can be an arbitrator. However, you stand an advantage because when they bring those evidence before you, you need to analyze. You need to now decide whose evidence to believe in. So obviously, being a lawyer, you have the advantage, but you also have the disadvantage. At times, we lawyers have made application very, very complicated. It's supposed to be easy. You're not a mediator, neither are you a negotiator, but you are an arbitrator, which means that you should be independent, impartial. There's so many things I'm going to talk about today, but I wanted you to just understand generally that arbitration has really taken its place. It's become faster because courts are, as we all know, is congested. So I welcome you, first of all, to this class. I'd like to thank the organizers, Adejumade Law Nexus, for inviting me to speak. And I hope that I'll be able to encourage you, teach you, speak to you. More than anything, I want it to be an engaging class where you can ask me questions and hopefully want to be an arbitrator. I've been practicing now for over 15 years as an arbitrator. I'm a chartered arbitrator. It basically is the pinnacle of what you can get to. We all know if you want to be a lawyer, we all aspire. If you are obviously not a solicitor but an advocate, you want to become a senior advocate. That's the equivalent of when you're a chartered arbitrator, but it doesn't come in one day. So, ladies and gentlemen, we're going to start with introducing you to what is called commercial arbitration. So that's the topic for today, and we're going to start. Since I don't know anybody's name and I can't see far, I think, are your names on your tag? No. So how am I going to be able to ask questions? So can we briefly, in 1 second, before I start, just know who is who? Can I start with you? Your name, please? The reason I want to do this is, you know what's called networking? You're not here just to learn. You're here to network. And it's important that I see you next time and you can tell me that, oh, Mrs. Ali, can you remember me? And I'll say, who are you? And then you never know. Maybe I need a registrar. I need someone as a training. You can come to me. And also you might need each other. So can I just know your name again?
My name is Modibuke.
Modibuke. And you, please?
Good morning, everyone. My name is Samuel Madi.
It'll be nice to know where you work.
I work at GLIs.
Okay. Thank you.
Good morning, ma'am. Good morning, everyone. My name is Oluwatu Simulano. I work at Zenith Bank.
Thank you.
Good morning, madam. All of those videos. My name is Kemi. I work at Alpha Better.
Alpha Better. What are you doing here? Yeah, the ones that you're always asking us for money. I know. Nice to meet you.
Good morning, all. My name is Fatima Madam Ibrahim. I'm the co-founder of Higher Legal Hub, all the way from Milan, Niger State.
Wow. Nice to have you here.
Good morning, all. My name is Adedayo Adebisoye Olaya. I work in the firm Johnson Lashley & Co.
Thank you.
Good morning, all. My name is Joyce Okixon. I work at Alphabet and Cosmos Development.
Okay, two of you already.
Good morning, everyone. My name is Amy.
So everyone cannot be the
Thank
one
you.
on the camera and on the laptop. I need it.
Good morning.
So tell me.
Thank you.
Good morning, ma'am. Good morning, everyone. I am Leslie Amugeli. I work with RAJ and
Wow, thank you for coming.
Good morning, everyone. My name is Bukola Abola. I work at the firm of Coca Practice.
Thank you. Let's be fast. We don't have time.
Good morning, everyone. My name is Peace Ogie, and I work in law schools.
Good morning, everybody. My name is Paul. I work at Chartered Arbitrator.
Thank you.
Good morning, everybody. My name is Mark Booker. I'm here at legal.
Thank you.
Good morning, everyone. My name is Emmanuel Chumara Brahim Demol. I work with Lex Imperial International Award.
Good morning, everybody. I'm Victor Atta. I work with acumen and acumen.
Thank you.
Good morning, everybody. My name is Faith Chua Akinori. I work with Pavestones People.
Thank you, everyone. And we're all lawyers, so at least it's going to make it easier for me to talk through what we're discussing today. I see that we have quite a few people online. We see your names. Since your videos are not on, apart from Galaxy, hello to you all. So it would be nice for your videos to be on so that I know you're concentrating, ladies and gentlemen. If you don't, then you might be doing something else. So I think for concentration, for you to gain for what you've paid for, please put on your videos. Thank you. So today we'll be discussing commercial arbitration. Arbitration, we all know, it's an alternative way to resolving disputes. We all know that there's court. So ADR has obviously getting stay, and I'll go into it. But today I'm introducing to commercial arbitration. I'll be looking at the act. Are you going to be showing them the slides, or I should just go through? Okay, so it's a bit small one. Okay. Anyway, commercial arbitration, the main law governing arbitration is the Arbitration and Conciliation Act, Cap 18, 2004. So you can see how old it is. It's actually 1990, and then it wasn't really changed. Became it's 2004. We've had this law, and that's the law we have now. Even though, fingers crossed, we might have a new bill that's we're praying the president signs into law before he leaves. We'll talk about that later. But at the moment, the extant law, the law we have is the ACA, Arbitration and Conciliation Act. Now it defines arbitration as it means commercial arbitration, whether or not it is administered by an arbitral institution. What do we mean by arbitral institution? We all know we have some institutes like, who knows any? The Chartered Institute of Arbitrators, there's the Nigerian Chartered Institute, we have the Lagos Court of Arbitration, we have the Regional Center. We have quite a few arbitration centers in Nigeria. So as an example, you are aspiring to become an arbitrator. It's advisable to go to one of them to try and do their courses so that you actually are grounded. You can apply to them and become an arbitrator. Nobody needs a qualification. So you can, if you know people, you have a dispute, you go. But you know what? Arbitration is so small, the industry is small. Once you make a mistake once and your award is not okay, you will never be appointed. So even though there's no qualification, we always advise you go through training. It's only through training you will know what it involves, because you can't go through arbitration and tell people that, oh, I went for a course and that's it. So go for proper training. This is a grounding And I really, really admire what LexisNexis is doing, because honestly, we have to continue to train ourselves. When I went to university, there was no course called arbitration. So it's something you pick up. It shows that anybody can be one. So we're going to be talking about commercial arbitration. We have the Lagos arbitration law, which recently came about. Well, it's not recent, but at least it's more recent than the ACA. That also defines what commercial arbitration means. And arbitration is basically referring existing and future disputes between two peoples to an independent, that's the important thing, an independent person to adjudicate upon that dispute. So I've given you two types of definition. Basically, what is important for everyone to know is that there must be two parties that are fighting. So when you as a lawyer, alpha, beta, all of you are in your various offices, and somebody took a transaction, a shareholders agreement, two people want to go into a business deal. Always remember that it is important that there's an arbitration clause. If you don't put it in and there's a dispute, you've resulted that you're going to court. Then you now decide that, oh, I think court is going to take a while. Let's go to arbitration. If you're fighting with someone, can you agree? That is why when you are drafting, that dispute resolution clause is so key. And that's what we'll be talking about. And that's what is called arbitration agreement. It doesn't mean one big agreement. That clause is so important and germane to arbitration. Because when you draft that agreement and it's well drafted, then when there's a dispute, you just go through the norm and you start your arbitration. However, if you have not, it's still possible to continue, but it means that you both have to now submit to arbitration and draft a submission agreement, which most of the time is difficult. Because one party knows that I don't want to, has things they have a good case and wants to frustrate the other party. And when you're fighting, it's not when you want to start discussing your mode of resolving your dispute. So ladies and gentlemen, key number one is when you're drafting, it's called midnight clause. Some people call it pathological clause. You know what it means? When you draft that clause and it is not okay, you will have a problem. And I'll give an example. Why they call it midnight clause is that some of us, you're arguing over the profit. You're discussing every other thing, but you know what? You never look into that, your dispute. You just cut and paste one and you don't really read. You don't even know if it fits your transaction. And then when there's a dispute, you realize that, oh my God, a 2 million naira dispute, a banking, you now put in it that there should be 3 arbitrators. Do you know what that means? When there's a dispute, it's very simple contract. You appoint myself, you appoint Mrs. Adekoya, you appoint Adida, Dumade, the 3 of us, we all charge. How much is the dispute? 2 million. I'm charging 300. The others are charging, do you understand? Because of the skill, let's assume you've spent over 600,000 on a dispute that somebody is just resolving. That's their expenses. Not talk of the lawyers. It makes a nonsense of your dispute resolution clause. That's why it is so important when you're drafting, you look at the skill, look at what it is that's the dispute before you start drafting that there should be 3 arbitrators. It's not every time you need 3. There are times where a sole arbitrator will be more than sufficient, but you must put the qualification and all. So that's what we'll be talking about today. So can we change the slides now? So I've told you what is commercial arbitration. Arbitration is basically, most of the time, to do with commercial. So you can't bring some things like criminal and say that you want it to be before an arbitrator. So it has to do with commercial transaction. And we all know what commercial transaction means. So commercial transaction is, I've defined it for you, it's basically any dispute that has to do with trade, commerce. So things like distribution agreement, construction, lease, tenancy, those are, you want to know what commerce means. So basically that is what we'll be discussing. We have something called investment arbitration, but that's to do with a host nation like government. We're not talking about investment. So we're going to be concentrating today on commercial, your day-to-day commercial activities. Although there's some things that cannot fall under commercial. Commercial basically are your day-to-day trade, goods, services, oil and gas, distribution agreements. I hope you all understand what commercial means. Thank you. Now, I've already told you, slide 4, I just want to explain to you that ADL has gained norm. What do we mean by ADL? It basically means alternative ways of resolving disputes. Now, when you draft your arbitration clause, at times we have something called a multi-tiered clause, where you say, in the event that there's a dispute, existing or future. First is that, for instance, and all those oil and gas companies, they do it. They don't come to us first because they have a multi-tiered clause in their resolution clause, which says that the first thing they do is they must go through a negotiation to try and see if they can negotiate and resolve. And then it says within 14 days, in the event that we're unable to resolve, you try and mediate. Mediation, as we all know, I'm quite sure we all go to court, some of us do. There's a Lagos multi-door court. What do? They mediate. It's now one of the prerequisites of court because they realize that there's so many cases in court that could have been resolved because they're minor. And multi-door court has actually been able to record success in resolving disputes without going to court. However, the disadvantage and the disadvantage to mediation is that it's not final and binding. And the mediator is not there to judge. The role of a mediator is to facilitate discussions. They cannot say that, oh, I think Bukola has made a mistake. They just listen to you and try and see if they can let both of you see reason why you should resolve. And they're not in a position to say that I believe Bukola, I do not believe Paul. Do you understand? So that is why at times mediation, at times we don't get to, until you find those terms of settlement. When it's signed and is lodged, then it is binding. However, an arbitrator is independent, is there to assess and is there to give something called an award. An award is the equivalent of a judgment. But when we render a final decision, we call it an award. And that is final and binding on the parties. Are you following me? Thank you. So that's what we'll be discussing today. So now, I've told you what arbitration is. It is, you must remember when you're drafting, that is not only the existing, but future differences relating to that subject matter. So when you're drafting, make sure you not only say that today's dispute and future, because you don't know when the dispute might arise. It might be at the end when you're trying to share profits. So, but the subject matter of arbitration, one, must be legal. So I can't bring lottery and all, you understand? So it must be legal. It must not be against public policy. And it must be capable of being settled under the Arbitration and Conciliation Act. So that is key. Thank you. So we're going to now look at matters that cannot be subject to arbitration, even though we say commercial and tax and is also supposed to be commercial. However, as we all know, issues relating to tax are not within the confines of arbitration because Section 251 of the Constitution specifically says that anything relating to revenue of the government is for the exclusive jurisdiction of who? The Federal High Court. So any dispute relating to tax, and this has been a bone of contention because there are times where Bukola is suing because maybe the VAT on that issue, on the money that they're disputing, charge VAT. The question is that a tax issue or is it part of that contract? And the courts in Nigeria, there's been various interpretations to what is tax. But the important thing for the purpose of today's discussion is that you should know that anything relating to tax is not arbitrable. Arbitrable means that it cannot be brought before an arbitrator. Same as bankruptcy, same as criminal matters and constitutional matters, because the Constitution provides for ways in which those should be resolved. So remember, only commercial. However, as I've told you, there's some issues that unfortunately cannot be brought before an arbitrator, because if you do, what will happen? Can somebody guess? If somebody brings a tax matter before me, and as an arbitrator, I preside over that and I issue an award, what do you think will happen? Fantastic. That's the right word. What did you say? Exactly. Jurisdiction is key. And what's your name? Sorry? Joyce. You see, jurisdiction is so key to my appointment. And it is important that you understand that I must always have jurisdiction. So when I'm appointed, first thing to look is, do I have jurisdiction? And I must never go outside my jurisdiction, because once I do, unfortunately, even though we say it's final and binding, it's one of the grounds for setting it aside. Thank you. And your name, madam? Blessing. You guys know arbitration already. So why are you here? Thank you very much. So we now understand that first thing is that we know what arbitration is. It is when you bring your dispute to before an independent and impartial neutral panel to resolve existing and or future disputes relating to commercial matters. Yes. And we've told you now that commercial, you know what commercial means, you know what also cannot be brought, because if it is, it's not arbitrable. Now, why do we go to arbitration at all? I'm always wondering that, why don't we continue with going to court? There's so many reasons why commercial-minded people these days decide and resort to arbitration, and it's really taking ground. One is flexible. The reason it's flexible is that it's a party-driven process. So when Bukola and Paul have a dispute, they decide who they appoint. When you go to court, can you decide who your judge is? So you sync with your judge. But unfortunately, there's advantage in it being party-driven. If you just decide that because Bukola likes Blessing and knows that Blessing is an arbitrator, but does not know that Blessing is not yet qualified, and chooses Blessing to arbitrate, and unfortunately does not handle the arbitration process, it's to our disadvantage. So you sync and swim with whoever you appoint. That's why it is important that you appoint people that are qualified and will be neutral. And we're going to go into those qualities later on. So flexibility is one of the major advantages, because when there's a client who's come all the way from England to Nigeria and has gone into a dispute, into a business deal, with a Nigerian, they like the idea that, we can decide on who to appoint, because then they can decide on appointing people that they know would be independent, because there's so many things people talk about the judiciary, but the important thing is that there's the flexibility, and the reason why, and that's one of the key reasons why people opt for arbitration, because you can decide on who both of you mutually agree to appoint. Two, it is private and confidential. That is so important. So that's why there are no precedents, unfortunately, even though there's some exceptions, especially in the investor arbitration. We're talking about commercial. If I render an award today and it's published, whatever we say, first of all, when you're having arbitration, you're having the hearing, you're presenting your evidence before me as a sole arbitrator, as an example. No third party can come into that hearing room except you guys agree. And that's part of the beauty of arbitration. So this can be the hearing room. It's only Bukola and Paul that decide to, and they bring their lawyers in. No third party can be part of that hearing. Whatever is recorded, whatever is stated also remains, because you sign the confidentiality. And some business-minded people prefer that, because one, they're trade secrets, they're things that they're discussing. Business-minded people also prefer it because it might be a long-term dispute, oil and gas. There's no dispute about, you did not meet the terms, or the schedule said you should supply this at a particular time, but they don't want to break that relationship. There's a small dispute about, maybe the contractor is saying, I owe you 10 million. He's saying, no, it's not. You can resolve that dispute, pay on and continue. And that's the beauty about arbitration. So you still continue your business relationship. You had a dispute over a small issue, is resolved, you continue. But if you're in court, it's protracted, the business does not go on. So that's one of these. And then there's quick dispensation of justice, because there's a time frame, the law is clear, you try to follow, so long as we lawyers do not put that plug and delay by bringing all your legal tactics to it, which at times has now been happening. Generally, arbitration is supposed to be fast, and you can resolve within a specific period of time. So that's another advantage of arbitration. Then the decision, which is the most important thing, is final, is binding. The scope of arbitration is stated. You know what the dispute is about. You can resolve, you can state all the things you want, because you can decide on the procedure, on a lot of things, which we'll go into. And lastly, it actually does save costs. Do you know what I mean by that? You can say that, yes, you pay me. In court, you don't pay. But the time you waste, your hourly rate of lawyers going to court, and then when you have a business transaction, business-minded people would rather spend ₦1 million to resolve than waste time and lose over 10 million naira because of the delay, especially in construction. So it actually does save time, because the time you save, time cannot be quantified in terms of money, time lost. Your hourly, if you can, one matter, you might be in court for a year, and we all know at times a year is even fast in resolving disputes. So those are one of the reasons why most people rather, result and go for arbitration. Now we're going to go into the meat of arbitration. The first thing is that we've told you that there's section 1, before there can be an arbitration. If, for instance, IK and Samuel, if they have a dispute, and they have a business transaction, they're trying to set up this, what are you trying to set up, like a dry cleaning business, and they've decided everything, this is where the venue will be. They've spoken about all the things they have to acquire, the money they're going to put down as deposit, shareholding, they've incorporated the company, and at the end, Samuel just tells IK and says, so if there's a dispute, we'll resolve by arbitration orally. When there's a dispute, is it possible? So it must be in writing. That's key. And that's what the first section 1 of the ACA, Arbitration and Conciliation Act, is specific as to the mode. So arbitration agreement must be in writing. An oral discussion between IK and Samuel can never, you can't appoint me and tell me to come and resolve your dispute. I'm going to tell you that where's the arbitration agreement. You can't tell me that if you now both agree, you must put it in writing. That's called a submission agreement. So first thing is that it must be in writing. What is writing? Writing could be that's their agreement to go into the dry cleaning business. If there's a clause there that says every dispute or any dispute in this matter will be, then that is that arbitration clause. At times it could be exchange of email where they were talking. But the problem we have is at times, so it says that it could be telex, it could be telegram, but the old ACA Act said it must be in writing. That writing has become, especially now we know with the technology, all kinds of things. The question now is, what is writing? And that was not clear and it was unambiguous. But the good news is that the new arbitration and mediation bill has now specified what writing means. We'll get there. So first thing I've told you, it must be what? It must be in writing and it must be documented. The second is, I've told you also, is party driven. Arbitration is party driven. And I've explained to you what that means. It's the parties that decide. You choose your arbitrator. You have the liberty to choose the venue. So in your arbitration clause, if you say that this arbitration, both of you reside in Abuja, what's the point of putting Lagos? The cost of coming. So that's why when you don't draft your arbitration clause properly, you give yourself problem. Both of you are in Lagos, you now put Kaduna. So any dispute arising in this matter, shall be resolved and then you put some venue. that doesn't make sense. Maybe for even the dry cleaning business is located in Ikeja. Why are we now going to, do you understand? So those things are important. So when we talk about you drafting a clause that will not get you into problem, these are the things I'm saying. You must state in it where you think the venue should be, not the venue, but the place. You might not, if you say Kaduna, that's enough. So just to explain to you some of the reasons that we have problems. Now that arbitration clause, in the event that there is a problem in future, it can be sued upon. So even let's assume that the agreement between them, for whatever reason, collapses, or the agreement between you is found to be illegal, that arbitration clause, you can sue upon it. And that's why they call it the doctrine of separability. That means that the agreement is separate from the contract of the parties because it can stand on its own and they can sue upon it. So it survives the termination of the contract, and that is part of the beauty of arbitration. So when there's a dispute, they can still continue. Do you understand? Even though that contract has been terminated, because that clause is an agreement that can be sued upon. So that what it means is that it's separate from the main contract. Are you all following me? Please do not hesitate to stop me at any point in time where you're not sure of what I'm saying. So I've told you, so now what are the essential things that should be in an arbitration clause? So an arbitration clause, even though it looks like a small clause of 10 lines at times 5, it can be so drafted that it has everything. One, the place, and the seats must be stated, which I've just explained to you. The law that you want to apply. If you want the ACA to apply, you say it. If you want it to be administered by, let's say, ICC, which is around the corner from us here, you put the rules. So if you do not put it, it cannot apply. If you want it to be administered by an institute, you say it. So the Chartered Institute of Arbitrators, the UK branch, an example. There was a time where there was a dispute because the person that wrote the arbitration clause, guess what he did? Said, if in the event that there's a dispute, it will be resolved by the president of Institute of Arbitrators. And then there was now the dispute of which one, because there's the NICAB, the Nigerian Chartered Institute of Arbitrators, and there's Chartered Institute. And that's, you won't believe, it took maybe like 2-3 years because it went to court to decide who the body, the right party is. Eventually, not because of the way it was written, there was actually nobody that was known as that. So they had to now infer that this is what they mean. You can imagine the time that's been wasted over the carelessness of lawyers, because that's not, unfortunately, the client's fault. It's actually your counsel that drafted. So we lawyers must be careful when we draft. You must state the law, the rules that you want to apply. You must state the language. If I'm French and I put that it should be administered in English, then you're now playing for transcriber, where that could have been avoided. The procedure for appointment is so key. If there's an arbitration and you do not state, you just say that, oh, in the event that there's a dispute, it will be resolved by a sole arbitrator. Isn't that a good clause? Is it good? No. Do you know why? So you said sole arbitrator, to be appointed by who? So in the event that Bukola and Samuel, they start quarreling over, Bukola says, but I really love Mrs. Ali. I want, and then Samuel says, no, but I prefer Professor Lawan. I prefer Professor Elias. The both of them cannot agree. You put your list, they are going back and forth. But you did not say in that your clause that in the event that the parties cannot agree on the appointment within 14 days or 30 days, the chairman or the president of ICC, Chartered Institute of Arbitrators, or court, you must say who that default person would be. If not, ladies and gentlemen, they'll be quarreling 3 months, they haven't resolved. I've had instances where it's taken 2 years to appoint because the parties, unfortunately, the lawyers did not draft the arbitration clause that made sense. So these little things, you might think it doesn't make, the procedure is not important, but that your clause is so important. You must ensure that you state what should happen in the event that you're unable to agree on the appointment. Then the number of arbitrators, the qualification. If I'm dealing with a construction contract, why are you bringing someone that's a medical doctor to be the arbitrator? Do you understand? So the qualification, depending on the dispute. For example, if it's one of dry cleaning business, you don't need to have qualification. If it's a simple, trade goods, but if it's a complicated one, oil and gas, why bring somebody that doesn't know anything in construction to be the arbitrator? So qualification, the number I've told you. For instance, those big contracts, they actually have, it's also multi-tiered in terms of the number. You can see a big contract that, let's say, one for like what $1 billion contract. You might actually say that in the event that the dispute is no more than 1 million, one arbitrator. Should the dispute be over 5, then 3? Do you know what they've done? They've capped it so that where it's a simple contract, you resort to 1. Where it is one that is complicated, you resolve to 3. There can never be. Can there be 2 arbitrators? Why?
Because of the balance of their work.
Exactly. When it's 1, the 2 parties do, but when it's 2, it's difficult. The reason why you have 3 is that there's somebody to preside and there's someone. So remember, there are only 2 ways, 1 or 3. Then, unfortunately, also, where you now draft your arbitration clause and you do not state in it the number of arbitrators, the ACA, unfortunately, will now be your default. And it says, how many? 3. And you can imagine for a simple contract, you need 3. So if you now make the mistake, you just say arbitration governed by ACA. Fantastic. But ACA says how many? 3. So when there's that simple dispute of 5 million naira, you have to now appoint 3. You can change it, but it will be both of you now agreeing that I do not think 3 arbitrators is. And if that man wants to be wicked to you, that knows that he owes you money, he will want all the money to go and say, okay, I'm sorry, I can't change it. Then you're now fighting. That's why we need to avoid those pitfalls. Are you all following me? People online, are you following? So that's what, do you understand the reason why you must make sure that your arbitration clause is so robust that it covers every eventuality? So we'll now go to, so what I've done, I don't know why it's not so clear here. Okay, it's clear here. Could you change it to, I just want to show you an example of what a good, so to speak, there's never a one clause fits all, but like just an example of an arbitration clause that you should have in mind. So this one reads, any dispute, difference, or claim arising out of or in connection with this contract shall be determined by the arbitration of a single arbitrator appointed jointly by the parties and failing agreement by the president of the Lagos Court of Arbitration. Can you see that he said what should happen in the event that the parties cannot jointly? He's also said that it should be a single arbitrator. Another one is, whereas disputes have arisen, that is what? Whereas disputes have arisen, what has happened? Can somebody tell me what that's existing? So that's called what? A submission. Because you see, they made the mistake of not doing what? Drafting in the agreement. So now you have to now draft saying, whereas disputes have arisen between Tola and Samuel, in respect of the construction of dash are dated, and the parties have agreed to refer these disputes to be finally settled by the arbitration of a single arbitrator appointed jointly by the parties and failing the agreement by the president of the Court of Appeal. I'm just explaining to you what the difference is between a normal arbitration clause and a submission agreement, which at times is difficult to now agree to. So we have different types of arbitration. We have the domestic arbitration, which is between parties within the same jurisdiction. Yes, please. Yes, please. Yeah, yeah. Yes. Yes. No, it doesn't. You can resolve it. It doesn't invalidate because nobody, as long as I have jurisdiction. So for instance, there's a clause. So long as both of you can now agree on the appointment, and it's not ultra vires in the sense that it's a legal dispute, you've just given your arbitrators more work because then you've given them also authority to do what they like. So where you have not stated what you want, the arbitrators now take charge. So for instance, let's use Benny as an example. Where you have not stated in your arbitration agreement that it should be in Lagos, and I'm in Ibadan, I can tell all of you to come and meet me. But in the event where you put it, I'm forced to, except parties, it can be changed, but parties must agree. And that is why arbitration, you will always see, they said, unless otherwise agreed by parties. That is the language in most of the sections of ACA, unless otherwise agreed, which means that it is parties. Whereas if you don't, but most of the time, once you've appointed someone that obviously has knowledge, they tend to drive it so that you're not, there's no delay. Have I answered your question? So, yes, please.
Your explanation just now, does it also apply to where the applicable laws, for instance? I'm looking at this sample of basic.
Yeah. Am I blocking you? Where I'm starting? That you can see. Okay.
So I'm looking at these examples now, and there's no applicable law specifically mentioned.
No.
So,
but they've said LCA. Well, as appointment, sorry.
I was going there to say that by saying who should appoint the arbitration in default, does that also imply what law is going to be applied?
Most of the time, there's the dispute resolution clause, there's the governing law. So most agreements would have the governing law being whatever, Nigeria, whatever. But if you don't, most of the time it's so for instance, if Chartered Institute appoints, ACA tends to always be the law that you would apply if it's domestic. If it's not domestic, we're going international, which is not the essence of today's. But for commercial, we all know we have the Arbitration and Conciliation Act. We have the Lagos Court, which is it's a variation, but a more modern version of our old law. And then we have, obviously, there's no other, what I'm trying to say, the main law in Nigeria is our ACA. And then we have the LCA. But most of the time you resort to the Arbitration and Conciliation Act. But if you use the LCA, you would have to use their law. If I use the Chartered Institute, ICC as an example, you can't appoint ICC, and ICC rather cannot be your appointing authority, and you want to attach the ACA. You'll have to use the ICC, which is an International Chamber of Commerce rules, and the rules are very different and extremely robust. When we come to deal with the International Chamber of Commerce, I'm actually a member, and I represent Nigeria in Paris because I'm a commission member. So when you use the ICC as an example, the beauty about ICC is that it's international. You cannot write an award and publish it. It has to go to, they have a court system where they actually would review. And that's why people actually, most of the time, like the ICC to be the appointing authority, because by the time that award comes out, it's so well written that it will be difficult for you to apply to set it aside. And statistics have shown, because one, they have a supervisory role which they play. So when they appoint someone, when you finish your award, it's sent to the court members who are actually experienced arbitrators. They will review the award, shred it, and make sure by the time you come out, there are no typographical, unlike our own system, where if I write my award, as an example, I publish it. Section 30 also says that you can apply for a correction. So because there might be mistakes within 30 days. So there's some other rules that come into place under our own rules, which most of the time would not really apply in ICC because somebody else, a third party has. I cannot show my award to a third party because it's against the rules. It's supposed to be private. So that is why at times, if it's a big dispute and it's international, obviously some people will use their rules. So it depends on the rules there's the LCIA, there's so many rules. And as Samuel just asked the question, it's always important that you actually state the rules, because that way then you're not, there's no ambiguity as to which rule should govern. Thank you. Yes, please. Your name again? Sorry? Kemi, how are you?
Okay, very well, thank you. So, excuse my voice, I'm getting older. So my question is, what if in the case where you are about to enter an agreement with an international company and the company insists on their own arbitration clauses, and also the place of arbitration should be in their own country, for instance, US. Is it advisable to use their own country as the place of arbitration, or you insist on the ICC?
I think honestly, these are all business deals. So that, for instance, it's just like saying that, I mean, who has the upper hand? The place, where is the place? Where is the business? Is the business in Nigeria as an example?
For instance, maybe like license.
You look at it, there's no hard and fast rule as to which rule should govern, but what tends to happen is you look at the connection, you look at the applicability, and you look at the relevance. At times, you don't just argue that you want it to be a Nigerian rule. If, for instance, what you're doing is virtual, or is, you know, and the rules make sense, but just don't. That's why you should always make sure that your transaction is such that you understand, and you cannot just agree to a rule that you don't understand also. And so you will look at the transaction, look at if the rules actually is germane to that business. So if it's their business and they're given a license, you're a franchisee, obviously their own rules will probably govern that transaction. But honestly, every transaction is different. And there's no hard and fast rule that you must insist that it must be ACA, or it must be Chartered Institute UK, or it must be NICAB. You have to look at your transaction and look at what makes sense before you agree to it. It's just like saying the number of arbitrators. Each transaction is different. You cannot say that for a simple contract, it must be a 3-man panel. You know, so you look at each transaction. What you're doing here is to understand the general rule so that you can apply it on a case-by-case basis, which is why I said there's no arbitration clause that fits all. You must look at your transaction and decide. You can't be putting a multi-tier dispute resolution clause if it's not a big organization, if it's not a big contract. Do you understand? So you look at your transaction before you decide. So as an example, there was a tenancy agreement the other day, and I saw the dispute resolution said, in the event there's a dispute, mediation. And I thought, wow, who drafted this? So what happens where you are not able to mediate? Can you evict without going to court? You understand? So some things doesn't make sense. So we have to be careful when we draft. We won't finish. So please, I'm happy that you were engaging, but I have a lot to cover, but I will keep asking questions because also it's educative. But please do.
Okay, so my question is, in a situation where we have 3 arbitrators and let's say one refuses to sign the award, can it be a reason to?
Yeah, the law provides for that. So the law says that majority, first of all, and that every arbitrator should sign. It also provides that in the event that one of, as long as it's not 2, in the event that one of the arbitrator is unable to sign, you state the reason and it's published, and it's in the act. So we're going to go to types. I've started with the domestic. We've actually discussed the international, and I've used the International Chamber of Commerce as an example of international arbitration, but there are others. There's the LCI in England. There's so many. There's Mauritius has their own arbitration center. Most jurisdictions have. Dubai is really, the UAE is really picking up in terms of arbitration. Arbitration has really taken, is really become popular and in high demand now for business relationship. We have institutes. I've used examples of them already, and they're statutory ones. So for instance, in INIPC, Nigerian Investment Promotion Commission, when it comes to, it actually states that any dispute relating to it must go through arbitration. That one, that's the law. Petroleum Act also, there's a section that talks about arbitration. So there's some statutes that actually provides the arbitration is the mode of resolving. So there's nothing about you trying to now say you want to change and go to court. So there's statutory ones also that makes it compulsory that you resolve your dispute by arbitration. Now, how do you appoint? Appointment of arbitrator is very important, and there's a section 7 of the Act that talks about appointment. And I've already explained to you how you appoint arbitrators. So first is that where there's a dispute, there's an arbitration clause. The first thing is that Kemi wants to sue, sorry, your name, sir? Bernard, because there's a dispute. And then what Kemi is not happy with your business relationship, she must send out a notice. The notice of arbitration, which is called a request, and saying that, look, further to clause blah, blah, blah of our agreement, I've attempted to try, you're owing us, and you've refused to pay. Further to clause 10 of the distribution agreement, notice is hereby given. So notice must be given. When notice is given, that's the date that is deemed to be, the date that Ben receives it is the date that is deemed to be the date that the dispute commenced. So that's the first thing. Then in the event, so once they've now sent the notice, both of them now agree that, and then that they want to appoint. There's something called list procedure, where both of you cannot agree. So Kemi sends in the name of a list of 3 people, Bernard sends 3. You might be lucky that there might be one name that's common. That resolves it. You just choose that person. Or the 3 of you do not agree. At times, I always think that it's always easier. Just pick up the phone. Unfortunately, when you're fighting, you can't. So she appoints her lawyer, the other lawyer, they both start throwing names until they find one that they mutually feel comfortable. I wouldn't want Kemi to appoint someone that I do not know, because I don't know if that person is Kemi's best friend. And Bernard too might want to appoint someone that's his colleague at work. Do you understand? So it's difficult to to decide on the person both parties agree is neutral. So in the event that that is going on for a while, and you have that clause that says that where they fail to agree, they have an appointing authority. That appointing authority, let's assume it's the Chartered Institute UK Nigeria branch. You write to the chairman, Mr. Agbola Akinola now says that, thank you. Looks at you must send the arbitration agreement with your request to the appointing authority. And when he looks at it, okay, there's a valid arbitration, he now looks at his pool, looks at the type of dispute, and he will now use his own discretion to appoint somebody that he feels has the requisite knowledge relating to that dispute. So that's how you appoint. Now, where the parties fail to appoint, and you did not now, unfortunately, put an appointing authority, you have to go to court. And the court at times can take 1 month, 4 months. So that is why you understand why you should have your appointing authority in default stated. Now I've told you, so there are 3 ways you appoint. 1, by parties. The second is arbitral institution, which is the third party. The third is, when I've told you appointing authorities are, such as ICRB, they have power to appoint. And then the last is obviously the courts. So there are 3 ways. Parties, both of you, appointing authority, third party, or the courts. And the courts, section 7.3 says that where parties are unable to reach an agreement on the appointment of an arbitrator, and where no one is expressly empowered to decide, which is like the arbitral institution, any party can apply to court for the appointment of the arbitrator or panel. But it will always be better to do it the right way by just having an appointing authority. Who wants to go to court to appoint? You know, the disadvantage is that you're back to being a judge. They appoint who you don't want. Yes, you are forced to now take a Mr. Joe blog that they've given that does not even have the relevant experience experience, but it's not the person you eventually would want. So I hope I'm making sense. So we've spoken now about the ways you can appoint. So we've spoken about the number of arbitrators. I've told you is 1 or 3. And I've told you that the default position is found in section 6 that says that in the event that you do not state how many, you unfortunately will have to have 3. Now, Blessing, is that your name? Jurisdiction, Mama. Sorry? Joyce. So we're going to your question now. Jurisdiction and power. The jurisdiction is the authority that you've given me when you appoint Mrs. Ali as your arbitrator. You give me, so I have to now look at what is the scope and my power to act. It represents the boundaries, within which an arbitrator or tribunal can deal with the issues. And I must not go beyond it. So let's assume that there's a dispute relating to this building, and I'm appointed. NECA has, maybe the owner has decided that they want to evict. Then there's a dispute relating to NECA house. I've been appointed to look at it, Then the adjoining building, maybe there's a problem now with the fence and the other side is suing, but because I was the arbitrator, I decided that, okay, since I've already been appointed now, I can deal with next building. What have I done? Do you have jurisdiction? So you understand, it must be within that scope. That's my jurisdiction. NECA house was what I was appointed for. It's none of my business about the next building. So your jurisdiction is your power to act within the scope of authority that you've been given. And you must never exceed it. And it normally comes from the agreement of the parties because, the parties already have the agreement. Is that agreement they brought to me? It's none of my business to now start thinking of adding other things to it. I hope I'm making sense. Powers are the tools for the arbitrator to work, and they come from the agreement of the parties and the law. They determine the procedure, the rule for my jurisdiction, and every other thing. So it is important that jurisdiction is clear. And you, as an arbitrator, you must know what your jurisdiction is, because without that, it's recipe for disaster and is also grounds for set aside. And the scope must never be exceeded. You must never go beyond that scope. So now, the qualities of an arbitrator. The first is that 2 things are so important that you must always know. And they're grounds. You must be impartial. So when they appoint me, and Kemi sends that letter, both of them jointly, Kemi and Bernard, Bernard or Ben? Bernard. They send me that letter appointing Mrs. Ali as sole arbitrator. The first thing is that I must accept. So my letter of acceptance in it, I must say that 1, I confirm that I am impartial and I'm independent. I confirm that I do not have any relationship with Kemi or Bernard. And if it's a company, I must check that I do not have any relationship. So you can't just say that, oh, I'm looking for money, then they appoint me. I've forgotten that. What's her name? Moyo's sister and myself are best friends. Do you understand? So you must, first of all, confirm that you do not have any relationship. And you must continue to disclose. So that's until I conclude. If anything should happen, and once you're appointed, you must not have any relationship. So for instance, there are instances where innocently, I see Kemi now. I didn't know her before, but we now met the following day at a wedding. So I sat next to her. We had tea. She was telling me nothing about the case. So, oh, Mrs. Ali, I like what you're wearing. Somebody takes our picture. Bernard sees it. That's the end. If they can go to court and say that I'm biased, even though innocently, God knows that I did not discuss the case, unfortunately. And if that should happen, what Mrs. Ali should do at the next meeting, just disclose and tell Bernard, unfortunately, I went to a function. Nigeria is small. We always meet each other. So I might not have known Farouk, but now maybe I've even seen him before, but you know, now that we've had a relationship, I might now see him next time. Lagos, so just say, gentlemen, I have a disclosure. 2 days ago, unfortunately, I was at a bar and I bumped into Kemi. What you should do immediately, once you're an arbitrator, you see someone that you have a case with, just immediately turn. When it's time to take picture, just turn, so that nobody will say that you met each other, because people are always looking for grounds to set aside, and we must be careful. You must not have a relationship with them. So when they appoint me, and I know that, so the good thing about ICC and the IB is that they actually, like, it's called the red book and the green book. They actually set those standards. So for instance, I used to work in Alukano body as an example. So 10 years after I left, they appointed me. I just immediately told the parties, and it was an oil and gas case. I said, gentlemen, I have a disclosure. I used to work in Alukano body in 1994. I left them about 10 years ago. I thought it was proper. I didn't need to, because the laws are clear. The red book says, where you have been a lawyer in a law firm 3 years, you cannot. But you know, you never know. They said when you are not sure, when you're in doubt, disclose. That's the rule. So immediately, both of them said, oh, no problem. Oh, thank you for disclosing. Do you know what I've done? I've built established confidence. If I did not tell them, and then they got to know, they're going to say that they appointed me, I connived with them, because I have a relationship with them, but I disclosed to them, and they said it was fine. Can they go later to now set aside? I immediately record it. Arbitrator disclosed prior relationship, parties consented, but more than anything, always look at the green book. It says the relationship, and it says what and what is acceptable and what is not. What is in green is fine. What is in red is no. So commencement, I've told you what commencement is. The commencement is when Kemi sent that notice to Bernard. The constitution of the tribunal is that appointment. Kemi chooses a 3-man arbitration. Kemi chose, what's the name, gentlemen? So Oluwatosin as a party appointed arbitrator. Bernard chooses Kemi. A blessing. Kemi and Bernard now have to jointly choose. No. Oluwatosin and Blessing now have to choose the chair. It's not the parties. Do you get me? So the two appointed, they're called party appointed arbitrators. Kemi chooses her party appointed Tosin. Bernard chooses Blessing. The two party appointed now chooses who? The chairman. Is it clear? And that's the constitution. So when that is now done, they now write to the parties jointly. So now they now choose, Olutayo is now the chair. So Olutayo now writes, nicely to Kemi. I'm always copy the parties. Never write to Kemi without writing to Bernard. It's a no-no. You must always copy. So there's this nice letter that is written by Tayo and says, dear parties, further to the dispute that has reference, dispute is called reference. Once you've started this reference, you don't say, you have to look like you know the arbitration. So you don't say that reference, in this reference, you don't say in this dispute. I'm giving you all the, so those are the terms. So you now say, Tayo writes and says, dear parties, further to my to the appointment of Oluwatosin as party appointed for claimant and Blessing party appointed for Bernard. The party appointed arbitrators have jointly appointed me, Olutayo, as the chairman or president of this reference. I hereby accept and I declare and I disclose that I do not have any prior or relationship with the parties that are known to me. And I also confirm my independence and impartiality in running this reference. And that is from that day, which is today, the tribunal is properly constituted. And that is called constitution of the tribunal. Are you following? So the next thing is the hearing. So now we've been constituted. You know what she does next? She calls the two appointed and says, Tosin Bernard, let's have a meeting. They have a meeting. We need to have a preliminary meeting. And I will go into that award. So let me just quickly, I think, how many hours do I have left? I just want to know, so I know, I'm asking. Okay. Don't worry, we're doing well. Preliminary meeting is held to decide the timetable. So what happens is that when they both meet, Tosin and Blessing, they look at the diary and they decide with the chairman, let's have a preliminary meeting tomorrow. Or they give the parties and they write to the parties and say that, okay, let's say June, first week in June, they write and they send an agenda. So that agenda, the first meeting of the parties is called, can you change it to preliminary meetings? Okay. So the first meeting that they ever had is called a preliminary meeting. And that's where you set the tone for your arbitration. At that meeting, have they discussed fees? Have they discussed who their registrar would be? Have they discussed where the venue would be? So all those things, the agenda is normally long at your first meeting. What type of hearing? You know, it's not every hearing that you must have witnesses. In banking, customer, they overcharged you, the caller, and you sued GTB. Is there a need to call any evidence? It's called documents only. So the documents, so there are different types of hearing. The documents only, the hearing proper, there's online. So anyway, I'm going to go into that. So basically, you have to look at the type. And then so it's at that preliminary meeting that you schedule the schedule. The parties will tell you, so tell me, what do you think? How many witnesses do you think you'll be calling? And you say, oh, Moyo says, I think I only have one witness. How about you? Okay, so it's a full hearing. Do we want it to be virtual or do you want, I think it's going to be complicated, madam. Okay, so we'll decide on the venue. Do you want to use my office to save cost or do you want LCA? Those are the sort of discussions you're going to have. Then you start telling, so when are you going to, madam, are you looking at your phone? Okay, so next thing is you ask how many, after the issue of witnesses, how many days do you think this will take? Then you don't talk about your fees. Oh, I think this is very big, complicated. I think we need a registrar. And then the lady in black, what's your name? Oh, you're not a part of us. Okay, gentleman, what's your name? The man in black and white. Yeah, you. Sorry? Okay. So we decided that Okpe is the registrar. So it means that you have a lot of work. Registrar's work is not easy. You're the secretary, you're the one. From the day I'm appointed, I never contact the parties. You go through my registrar. And that's the rule number one. You never communicate with the parties orally. Never. Never. Only by writing. That's why at times, and you just go through your registrar. So nobody can tell you that you communicated with one without the other. Do you get what I'm trying to say? So we do all that. And then next thing is you now decide on the timetable. Moyo, I don't like you typing in my page. Put or you leave my, I don't like it. You're just distracting me. So next thing is you decide on the timetable. Who is filing first? Always who? Claimant. How many days do you think it will take you to file? She will tell me that I need 21 days. But this is arbitration. Do you really need 21 days? Madam, I do. It's party driven. I can't force. But if I think she's being unreasonable and she asks for 40 days, I'll say, Kemi, please, can we please be a bit reasonable with the timing? Why do you need 40 days? And by the time we go back and forth, she probably will say, okay, madam, 14 days. Then I'll ask respondent, how many days, you know? So all the filings are put in place. We set the timetable. Then we set date for hearing. And then at the hearing, from that time, my registrar is the one to ensure that my timetable does not derail. Parties keep to their time, but they never do. They will always come back and ask for time. But do I have a choice? It's party driven. So I always tell them that if you delay, that's your problem. I said date for my hearing, you move that date if I'm not free. Because on that preliminary meeting, most of the time you set everything. And then the most important thing is you now ask for your fees. When the people that are fighting, once it comes to fees, they become best friends. Always. It's been my experience. Then when you now say that, well, this dispute is 10 million, the arbitrator's fees based on the scale of CRR, you would have calculated before coming. You do as if you haven't calculated. You now, so I said that, oh, so my fees are about 2 million naira in this case. And they will say, wow, madam, is there anything you can do? You're not supposed to negotiate, but most of the time you tell them that, well, there's a minimum, an average, and maximum. There's always a scale. So you always would resolve. But you see them, what I do is I just tell them that parties, you can discuss and come back to me. So they will go and discuss. The two people that were fighting, they will discuss, but they will come back and tell me what they think my fees should be. I agree, everything is set. Then you send out something called, when we finish, who knows what it's called, what I send out to enumerate what transpired at preliminary meeting. Exactly, order for directions. What's your name? Sorry? Ayola, fantastic. So you now send out your order for directions, called procedural order number 1, where you state everything that transpired. And that order for directions sets the tone. And my dear Okwe is the one to send it out. And, and that's basically arbitration. So I've told you, you set the timetable, the scope, order for directions are made after the preliminary meeting. And if for instance, they're not happy with me, and Bernard says that he doesn't want me, that's the time to challenge. Once you understand, at the first, as we start, madam, I have a preliminary objection. What's your objection? I object to, and they would say the reason. If you think it's you cannot, then it puts it in. I ask the other side to respond. But the good thing is that I have the competence to rule on my own jurisdiction. It's called competence rule. So they're challenging me. I'll be the one to rule. Do you understand? And I'll make a decision. And that's what the law says. And I'll say that, well, I've listened to the two of you and I will rule. So, all the arbitration, you've let it in one day. So that's the order for direction. And then the next thing is the hearing, which we've discussed already, constitution of tribunal. So the hearing, I've told you that you can have oral, documents only rather. And when it's oral, then the parties present their cases, or you can do both oral and documents. That's very clear to everyone. So the hearing now will commence. Then at the hearing, so they've now finally filed everything with Okwe. I always insist that they should give me a bundle. I don't want today is fight. So when they filed everything, eventually, there's a pre-hearing where I tell parties that confirm, please, can I just know, can you have your bundle labeled 1 to 3, if it's 200 pages? So I know C1 to C2. So when I'm referring to documents, it's easy for me in my award to refer to those pages. And everyone, and then the other side, I'll tell you, label yours R1 to 200. Your witnesses on oath, everything is stated. So that on the day of the hearing, we're not looking for documents because there are 2 bundles. And you must always prepare to serve each. So you don't give just me, the other party too must have a bundle. So the Evidence Act does not apply. Do you know why? Because it's not court. So for instance, all that argument that it's not original documents doesn't, I bring it before me, I'll just tell you that. Can you please, what exactly is the issue here? Is it that the document does not exist or that you're saying it's not original? Original, not a copy. You're not denying the existence of the document. So what are we talking about here? And I'll allow it. Because strict rules of evidence does not apply in arbitration. Because if it was a surveyor, does he understand all that? Do you understand? Or if it's a medical doctor that was the, so it's not every time that is always, so strict rules, must always remember that the representation doesn't have to be a lawyer. Kemi has a dispute, alphabet size about money. His friend in the office can go and they can present their cases. So you don't need to be a lawyer. to actually be, so, and you can actually represent yourself, because that's arbitration. And I've told you about it being confidential and private, and you must always control your arbitration. Section 14, if you don't know anything today, just know Section 14 is the mantra for arbitration. Each party must be given equal opportunity of presenting their case. It is the rule that you must always know. So that means Bernard raises a point. Never say that, okay, if you believe, I just rule. When Bernard challenged immediately, Kemi, what's your response? Anything, even up to a challenge of documents, photocopy, I know I'm going to accept it. Remember, I can't just say so. Also, Bernard, what's your response to that? He will say so, then you rule. Parties must always be given equal. If not, they're going to tell you a bias. So you must always ask the other party, what is your view? Everything you're doing, may I have your response? It's not you must always. So that is the main thing about arbitration. And obviously control, and don't let it get out of hands. Don't let the parties be the ones deciding for you. Now, what's the burden of proof? It's not criminal standard. So it's basically preponderance. You look at the evidence. I always just look at it, and it's based on its balance of probabilities, not beyond reasonable doubt. And not all facts needs to be proved, as we all know. Admitted facts are presumed. And then for me, except it's really, really illegal or something, I always admit all documents. But you know, the thing is that the law says that it's for the arbitrator to determine the relevance and materiality of the documents that have been presented. So the fact that I admit it doesn't mean jack. I can admit it when I know, for instance, there are cases that have come before me, like I can use an example. So you claim that you are the claimant. The documents were with you. You did not present it. The other side asked for it. You refused to. Obviously, I won't say anything, but already that shows that there's something you're hiding. The invoice was in your possession. He doesn't have it. He asked for the invoice. You refused to bring it. Fine. And he brought a copy. You're not saying, I won't say anything. Obviously, so the relevance of every document is for you as the arbitrator to determine. So when you even admit, doesn't mean anything. So that's always admit, because it's for me to determine if I think is relevant, the materiality, and the weight to be attached to every document. And all these things are in the act. So, yes, please. Yeah.
Evidence Act talks about criminal allegations are made because of even one case. Does such scenario play out in arbitration as well? And how is it handled?
So if somebody comes before me and they're saying that somebody committed fraud, you understand? It's not before me, but it is part of the allegation. It cannot be within the scope, because first of all, has it been proved? It's not for me to now be. That's burden on criminal, and I'm supposed to be dealing with commercial issues, and that's why you need to be careful about that, your scope. And that's why when they finally bring all their documents, I ask them, what are the issues for determination in this matter? Kemi said the issue for determination is about the fact that Bernard owes 2 million naira for services that Bernard rendered. That's the issue for determination. So I try to ensure that I stick to my issue. And you're now bringing things that are not relevant to that issue. If once it borders on criminality, it's beyond outside my scope. I deal with the issue that's before me, the documents, and I find people will always say, so when you talk about credibility, that's obviously you're looking at who, if you think they're telling the truth, that doesn't mean that the person is fraudulent. So you need to be careful. And that's part of you knowing how to evaluate evidence. It's about evaluation. Have I answered your question? Thank you. So the competence of witness, attendance of witnesses, they also come before you. They can swear or affirm. The registrar always does that. Yes, sir. Your name?
My name is Papa.
Nice to meet you.
I wanted to know if I have a couple of questions, but can we
Shoot
wait,
off.
or should I just?
As you like it, I'm indifferent. It's part of the engaging.
If there will be chance after the session to ask questions, then I can just wait and answer everything.
No problem. Are you sure? Better ask. You might not have time. Ask one question.
Okay, will be relevant to the provisions of the Evidence Act, which you just talked about. I was just thinking generally that the primary purpose behind which Evidence Act was created, so when it comes to entering documents, like they require it to be certified to ensure it's authentic.
Yes.
It comes from the appropriate source.
Exactly.
So I'm just speaking now in the context of arbitration now. Yes, Evidence Act doesn't apply, yes, but how then does an arbitrator really verify the authenticity of the documents? If you don't not strictly, if you don't at least to an extent rely on like some of the requirements of the objection that okay, this document you are telling to me, like you got it from someone, so it's certified by the appropriate body. So like how do you really
so you are, thank you for that good question. Now, first of all, you want to win. I think you would have. That's why they said it's for the arbitrator to determine the weight to be attached. If you present a bad case before me, there's a reason you did not. So it's for me to determine what weights to attach to documents. So if you don't do the right thing, you determine the weight, but doesn't mean you won't admit it. It's in your evaluation of the matter of the case before you and the evidence has been brought that you decide what weights to attach to it. So if it's not original, why don't you have the original? You did not lay your case. You did not tell me why. You didn't tell me that it was because they stole somebody broke into your office or it was damaged. And if you know that it was a copy and you did not certify it, I know the weight to attach. That's why I said that even though it doesn't, strict rules does not apply, it's for the arbitrator. That's why you get arbitrators that have experience to determine what weight to attach to it. What is it material? Is this relevant? For you care, you're arguing about what is not even relevant to the issue. Yes, please. Can I go on? Thank you. So obviously there are times where we need experts, but not every time. It's a waste of money at times. So if you think it's relevant, you bring. Because the more people you bring, the more time I spend, the more hourly rates I charge. So at times, if you know that you need an expert, you bring, it's allowed. There are times where it's a banking transaction. There's instances where they've had to bring auditors in because it's relevant, because of the documents involved. So it depends on the scenario. I've had instances where I've actually had experts, even in oil and gas, appear before us, but it must be that it is necessary. And when they come, they also swear that's what they're given, and then the expert evidence is before us. So, and we now know that when you finally finished, you've presented your case before me, and then I now close the hearing officially. And then I ask parties, how many days do you need to write your addresses, your final addresses? They ask for time. And then you adjourn for first of all, they send it in through the register. Always remember, for arguments, everything is sent in. And then you now close for officially. What do you close for? To write your final address. I don't normally ask them to come. It's not necessary. Send it in, it's written. Send your written address, except it is really, really complicated. Most of the time, you just send it in. And then that's the day that officially it's closed. And then we retire to write our awards within 3 months from that date. So that's basically A to Z of arbitration. So when you finally now write that award, I mean, when we've made a decision, it's called an award, and it's the decision that's been reached by the tribunal at the end of the proceeding, is binding as if it's a court judgment, and can only be set aside under very, very, very minimal conditions that's stated in the Arbitration and Conciliation Act. So from the day that I finish, when you send it in, it's called publication. You don't render, judgment, they say, but we publish our own. It's called publication. You publish your award. And when you publish it, from that day, I become functus official. That means that my task is over. But you know one thing that I forgot to tell you, those are my fees. I always make sure that I collect it before the hearing. Because once you don't collect your, so in my order for direction, I state it, parties must pay equally within 30 days or 20 days of that preliminary hearing, which is long before the hearing, because you don't want to start arguing or do you want to have a lien and not publish your award because they have not paid. So that's, so now we're going to talk about what do we mean by award. So, yes, please.
You say the award is public.
Yes, please.
It's not for public consideration.
It's sent to the parties, but the word is just publication, but it's not to the whole world. It's sent to the two parties, and normally you send hard copies and soft copies. And it's.
Is there any instance where speaking that's handling the
not domestic, but ICC would do that. Yeah, they do all that, but normally for domestic, once they're appointed, they don't have anything to do with you. They don't even supervise. Chartered Institute doesn't, neither does NICAB, yeah. Who's the third party?
For instance, maybe national third party, but that third party was not included in the arbitration, and now an award has been given. And that third party now getting rid of the resolution flag to know what is award.
I don't know him now. It's party driven. I only know two parties. I don't know a third party. If the third party has interest, it was not joined. There's no consolidation. There's no joinder. It's not possible. Except if there was a joinder, but it would only have been joined since now. It wouldn't have been joined after the No, this question is about. The question he asked is different. He didn't ask for a joinder. He asked that after the award has been published, can he ask for a copy? Okay. Okay, can that be consolidation? Yes, there can be. Yeah. Yeah, they. Oh.
Yeah.
So sorry about that.
Are there is total known as the third-party interest in a particular transaction and now around that again? And next step of it now aware that the arbitration proceedings are going on. And he should apply for copy of the award.
And I've just responded. I said that arbitration is party driven. There are only two parties before the tribunal. The third party was not joined. There was no consolidation. There was no joinder. So for the purpose of the arbitration, he's not known. The only way it could have was that if the parties at the inception or during had actually requested for him to be joined, and there are rules for joinder, there must be relevancy and all that. So if he was joined and he was a party, yes. But if he's not joined, the arbitrator would be going beyond the scope by sending the award to a third party. It's private and confidential until it's published. At the end of the day, between you, I mean, once it's published, one or two people always get to read it, but that is not your own. But for our own purpose, it is only to send to the two parties. But you can imagine where you've actually now appealed against the application for set aside. It's sent to court. Your public is more, so it's at the end of the day known to the court, and then it becomes a public knowledge. But only in those instances, because by the time you're applying, you attach the copy of the award. You state the reasons why you think it should be set aside. Yes.
The award is not binding of this third party.
No, it's not. It's not, because I don't know the third party.
There's no right there. Hello, everyone. Thank you very much for the session now. My question is on the dates and also on the timeline to publish the award. I think you mentioned earlier that the award must be published within 30 days or so.
The award after
Yes.
after you've retired, No, it's 3 months or 6 months. No, it's not 30 days. Never. It's the correction. I said where it's been published and where it's been published, and one of the parties noticed typographical or similar, something, all those minor corrections, you can actually apply for an additional correction to that award within 30 days. And when you make that application, the tribunal has 60 days to correct and send out an amended. It's called additional award. You're welcome.
My question is, I've seen a situation where an arbitrator delayed publishing the award because parties are not paid the fees. So in that circumstance, I have two questions. Is it a legitimate ground to withhold the award? And if you withhold that award beyond the time you ought to publish, what's the impact on the award?
First of all, in the old act, the tribunal could not lay lien. Do you know what lien is? Basically, it's to hold on to the award until you're paid. But the new act, which I'm going to go into, I hope there's time. Actually, now there's a provision that allows an arbitrator to legally have a lien on that award until it's been published. But till now, as at today, there is no law that actually allows an arbitrator to do so. But hopefully, once the A&M bill is passed, which once the president has assented to it, because it's been passed, hopefully, then we can legally do so. But that's why it's always advisable not to be found in such a situation where you're actually now asking for your fees. I would, most of the time, not proceed with the hearing. I won't say that I'm not proceeding, but you'd request for your money so that you're not caught in that sort of situation.
Okay, sorry, man. Sorry that I'm taking you back. It's about the registrar. Do they have to disclose if they have a relationship with any of the parties?
Yes.
They have to disclose.
Yes. And it's not in every instance that you have a registrar, because if it's such a simple dispute, the parties won't pay. But they will ask you. Both parties must feel confident and comfortable with that registrar, because you always have to ask their consent. So I can't just tell them that, oh, you appoint and say that, oh, I like IK to be my registrar. Both parties that have the dispute must consent that they like IK or they're comfortable with IK.
Okay, so my question is, after judgment, is it right to say that the arbitration tribunal seems to be functions official, where maybe there's an error detected in the award itself?
They were functions official until when that correction came.
Okay, so they still become
yeah, exactly, because there's a timeline also, 30
yes.
days. It's only 30 days, yeah. So after 30 days, that's what the law says.
And then they become functions official.
Yes, yes. And it's an award, not a judgment.
Yes.
All right, I have two questions.
I won't finish my lesson.
It's just, it's not so long. One, can an arbitrator revise his fees? If, for example, the hearing grants or there's a delay, which is the fault of any of the parties, can one revise the fees that he has initially charged? And then secondly, who bears the responsibility of paying for the fees? Is there a provision for maybe a 50-50 agreement or 70-30? Yeah.
Thank you. Two good questions. The first question is, that is why you need to know the facts before you fix your fees. It will be difficult, if not impossible, for an arbitral tribunal to midway not asking for a revision of fees, except it is really unusual or they brought in more issues. That's why you don't rush to fix your fees until you know the facts before you. The second question is relating to fees. What tends to always happen is that your fees are paid before, whether it's domestic or ad hoc, which is what I was going into. But where you're in scenarios where, what's the question again? Forgotten what I was saying. Revision of fees. Okay, so no, I've spoken about revision of fees. Okay, so who shares? So the question is, first of all, in domestic, parties share 50-50. The law provides that in the event that one party does not pay and you want to proceed, the other party, the claimant or respondent, be that we can actually pay fully, and at the end, when you render your award, you now issue. But normally, it's the party that wins is compensated by the other parties. So most of the time, it's the what's it called? The portion that's been paid is normally repaid by the losing party. So can I just quickly proceed with the what's the time? It's just 11. I have time. Okay, so I have 15 minutes. Okay, I'll rush. So awards, so there are different types of award. Interim is where there's an interlocutory, application has been made in between, and then you render the award for relief. There's partial award where there's an application for some part of the award to have been written before the final, and the final settles all. So I'm just going to, where, for instance, you start an arbitration, and midway, Kemi and Bernard decides that I think we should resolve. And they both ask the arbitrator that I think we'd like to adjourn for a few days, and they come back to me and say that, Mrs. Ali, we've decided that we want to resolve this dispute, and they bring their terms of settlement. So what you now render is called the consent award, and which is still signed and binding, and you can actually take to court. So once you've issued an award, it becomes binding on the parties, and they can sue on it. So what are the formal requirements? I'm going to have to rush. It must be in writing, as obviously you brought your dispute to me in writing. And the place of awards must be stated at the end. You must state your reason. So I can't just say that I find for Kemi without saying why. You must state that I believe the evidence and state the following reasons. You must specify the date is issued, and it must be published and delivered to the parties. I've already spoken about what publication means. So you must never in your writing say, I give an opinion. You must be direct. You must make a decision. I find. You don't say that I think. Always there must be a finding or a holding. And you must never make a recommendation. If they brought 4 issues before you and you deal with only 3, it's grounds to set aside. So you must deal with every issue that has been brought before you and cover all issues that has been raised before you. If not, it's grounds also to set aside. And you must be certain and make sure you are clear as to what your decision is. They must not be such that they're still trying to speculate that what is the tribunal saying. And the language must be easy. Just don't speak complicated English. So I've told you what domestic award is recognized and enforced in Nigeria. So if I render my award, you can actually go and enforce it. International arbitration is recognized and enforced under the New York Convention on Recognition and Enforcement of Awards, which is not what we're dealing with. About 160 countries or more are signatories to it. So that beauty about it is that if I render an award here, it's international. It can be enforced in any of those countries, but that is not beyond the scope of this training today. Now, what is recourse against an award? An award is binding, as I've told you, and is enforceable as a court judgment, but it has to be registered. Where you seek for correction, I've told you what needs to be done. The grounds for appeal are so not that many. So you must come under that scope that is beyond the scope. But scope is so loose that at times things like misconduct, a lot of things have been, the cases to Lawudra and Co that it's difficult to find out. So people hide under various ways, but honestly, it's difficult for you to sustain grounds for setting aside, except it is really, really germane, and you can prove that the arbitrator went beyond the scope of his jurisdiction. And we all know what jurisdiction means. The grounds for refusal to enforce. I want to quickly deal with the new A&M bill, so I'm going to have to rush a bit. A party to arbitration, so where there's incapacity, you didn't give proper notice, all those things are grounds and is in the law. Now, costs. What do you mean by costs? Because the cost of arbitration is part of your fees. So the cost of the of my fees, expenses, if you hire a room, all those are all the costs that you will. So the winning party will always claim their cost back, and all your legal expenses, so long as you claim it, when you win, you get your money back. Now, I want to rush to just quickly deal with something that I think is interesting for everybody to know. We've always had the Arbitration and Conciliation Act 1988. It's 35 years old. It's been a cause of concern for most of the international community because we're not up to date. So many things that we're still relying on has been amended. So that's why one of the reasons why Nigeria has not been seen by the international community as a very favorable seat. And there's been a lot of clamor for change. But the good news is that recently, just a few days ago, on the 10th of May, it was passed into law by the National Assembly. And what we're waiting for is the president's signature. There's a lot of likelihood, we're praying it happens, that the president signs this into law and Nigeria would now be able to stand and be like every other nation. So there's a new bill. It's called the Arbitration and Conciliation Bill. And I think it's just essential that you just have a slight glimpse of some of the innovations. So the first thing is I told you the arbitration must be in writing. So we've had a problem where some people would say that, oh, we wrote this and it was in an email, and there's been disputes, but now it's actually now stated in our bill that electronic communication is a form of arbitration agreement. So you can actually show me your email exchange and there won't be any dispute. I won't be quarreling over, was there an arbitration agreement? Was there? So we're really now becoming more innovative and tech savvy. There's something in the act that I don't understand, and I think it's something we should discuss. It's called an award review. You publish, and the only thing you can do is go to court. Now, there's a provision for now something called an award review tribunal, where if you're dissatisfied, instead of wasting time going to court, you can go to the award review tribunal to challenge some grounds. But unfortunately or fortunately, because they have to be, well, I mean, what they've done is in the act, the new bill states that for you to go to the award review tribunal, your agreement must have provided for it. That's the first thing. Then the steps and what needs to be done, how do you appoint? So where you're not happy, it must be the same number of, so if it was a 1-man, it's a 3-man, tribunal. The next thing is the appointments. There are very strict rules in terms of the number of days that it must be appointed, acceptance within 2 days, the publication of the review panel within 30 days. So it looks like a good review, but I have a problem with the review tribunal because the party can still go to court on some circumstances. So for me, I'm wondering, isn't it another delay in enforcing and also giving the claimant or the respondent another bite at the cherry? Because the tribunal has rendered an award, but the circumstances in which you can go to an award review tribunal are also limited. It's novel. We'll see how it goes. But the good news for each and every one of us is that now there is a way you can have your award reviewed within limited time, as opposed to going to court and spend a longer period of time. So it is heartwarming. Another innovation is third-party funding, which is the point Bernard was trying to say. Third-party funding is slightly different. I'm quite sure we all know about the P&ID case. If you don't, then you should go and read up on it. Who don't know about P&ID? Okay, there's a case in Nigeria. There's an award in England that if it goes through, Nigeria is going to be in real it's billions of dollars. And it was a case that the award was against Nigeria. I can't go into details, but Nigeria now came back and, well, in our defense, they said there was fraud, that the officials of government where they bribed some people. Anyway, it's a long story. There's a fraud allegation. But the point I'm making is about third-party funding. That where I have a case, millions of dollars, and I would like to sue Kenya, but I don't have money for lawyer. Now there's a provision, and where the third country only in Africa, Singapore and Hong Kong and the only other countries that have provision for third-party funding, where you can actually, the people that this is their specialty, they look at good cases and they buy into it. So they pay my fees, so that my lawyer's fees, so I can sue Kemi, and they will now have a stake and become an interested party in my matter, even though it's my case. The third party funder said that you have a good case, Mrs. Ali will fund you. But when that money comes, but your agreement between your third party funder is your problem. So maybe out of my 10 billion, they take 40. But they will go all out to get the best lawyer so I can win that case. So now, for the first time, Nigeria has made third party funding is legal in arbitration. And it's the way to go, because most of the arbitration cases are actually, they're not like minor cases of I sue you for 2 million naira. They're normally international. The amount involved against government is enormous that an investor might not be able to afford to sue government, except you have a third party funder that will be able to. So now we have third party funding is acceptable, but the rules that govern it. You must disclose that there's a third party funder. So I can't just go ahead and sue Kemi. I must disclose that there's a third party funder, because for all you care, that third party funder there's a conflict of interest. So you must disclose it, and you must not only to have, but to the arbitrator in case I'm also conflicted. So there are conditions that need to be. I just wanted you to just have an idea of the numerous innovations. Then, Paul, you mentioned about consolidation and joinder. Now it's legal. We have provisions for it now in section 30 and 39 of the new bill. Also, interim measures. Before, the old act provided that you could apply to the tribunal, but there's only a limit to which the tribunal can do. I cannot order a third party. You understand? I'm not a court, so I can't compel. So now there are various provisions now in this new rule about interim measures of protection. The one that I think we've been interested in most is the emergency arbitrator. So where there's an emergency, you can imagine the protocol and what I've told you we have to go through to appoint. But there's an emergency, you need an arbitrator. So there's now a new provision for emergency arbitrator where before the arbitrator, the panel is appointed, there's something urgent that needs to be done. You apply, within 2 days, an emergency arbitrator is appointed. It's given less than 3 weeks or so, you understand, or a month to render his award. But it's in emergency situations, and really is a welcome development, because there are times where you can't wait until 3 months, filing of evidence before you get. So where there's an urgent need, you can now apply for emergency arbitrator. Then there's another, let me just finish, please. The statute of limitations. I've told you about lien, because we don't have time. I'll take all questions. Now there's provision for lien, which we discussed earlier on, where my fees are not paid. Now I'm legally allowed to hold on to my award until it's paid, although there are exceptions. And then there's immunity. Immunity means that I'm protected now against any sort of thank you. So, ladies and gentlemen, I am open for questions. That is the end of my small tutorial on commercial arbitration. I hope I've been able to impact something. Thank you. So if anybody wants to ask questions.
I would like to ask a question.
Yes, sir.
So I understand that depending on the industry in which a business operates, some are not so amenable to arbitration. For instance, the bankers. Because I learned that when people sue a bank, they draw a big bill that, okay, they have banks that are their bank, they have money, so they always want to ask the court for even some in damages. And the banks usually prefer, rather than arbitrate such issues, because they ask themselves, where do we start to negotiate this stuff from? They rather just call a litigator and pay them maybe $1 million or 2 or 3, depending on what is being discussed, and have them go and fight the case in court. So I like your opinion on that, and also hear it's being from the banking industry as well. Do you want to speak first?
Okay, so if I get your question very well, it's you're asking why banks seem to prefer
Litigation
over
Arbitration.
ADR. Yeah.
I think it's Nigeria here and there, right? Because, in any case, the banks will always want to look at its interest. And then again, that also brings us back to what our facilitator has said. When we don't have these things in the agreement, it gives parties the opportunity to explore as many options as we can. But if it's something that is already in
Expressly
the
stated.
agreement, expressly stated, it might be difficult for. So if it's not there, parties will look at what would be in their best interest at that particular time and explore the option. So I don't know if
I think you're right. I don't know if Madam wants to
I personally think that it's a case, it depends on the dispute. And so your name again? Tosin has already said it all, which is the first fundamental remark I passed, that it's not when there's dispute that you decide on your dispute resolution provision. So long as the parties have decided. Well, fortunately for most of us, there are those fine prints in banking transactions, and that we don't look at when we apply for loans, and the standard clauses. But I think honestly, the mindset of most organizations are changing, and most organizations even are all in favor of arbitration, at times mediation, because going to court, we all know, is a nightmare at times. So I would say that it depends on the case. And at times it's not about the loan, it might be other issues. So each case depends on what mode of resolution they would adopt. But I don't think it is true that banks have the big pocket, but I'd also think that these days they're changing, because they realize the number of hours or time they spend from multi-door courts before going to, because there's so many cases of banking transactions that are mediated upon, and most of the time it's a waste of time. So my answer is that it really depends on the transaction. So the lady in red.
I will pass the mic to that, so the mic is
okay, my one small comment to that question, if that's fine.
Yes, that's fine.
Okay, so on the last question on banks and arbitration. So the thing is, it's not really that the banks actually shy away from the arbitration, but just like you said, I've handled some court ordered arbitrations that
exactly.
the parties will go to court and the court is okay, go to arbitration. And while the arbitration, the matter should be settled, while for some it will break down and have to revert to the court. So for just like you said, some customers should, because the banks have the big pocket, and they think they can easily get some awards or damages against the bank. It's not necessarily that, because even before the bank will rather even go to court, they will have to have their own defense too. And when they see that, okay, this matter is a bad one, they rather just settle than just even proceeding through litigation. So the banks really do not shy away from arbitration. I find the best of the case like this.
Thank you for that comment.
Thank you, Mark, for a wonderful session. So my question is in respect to interim measures. So I know that a lot of contracts state that when a dispute, it goes to arbitration, but if it's you're looking for an injunction, something like that, you can quickly rush to court and come back. So I know you had said for the award review tribunal, it has to be in the agreement. I wanted to ask if this one also has to be in agreement, because would that not be like a conflict if you're saying go to court and then the law says you can quickly rush to the for arbitration?
For interim measures,
Yes.
you follow the law. The law is clear. The arbitrator, there's some powers we have as arbitrator. This is one of the provisions. It's actually in the law. So long as you succumb to arbitration and mediation bill, even in the ACA, the extant laws that we have, there's interim measures there, and we have the power to do so. The only problem is that if there's a limit. So if it's subpoena judice secum or subpoena, for what's it called now? Exactly. So if you want to apply for that, I can order a party, but I can't order a third party because the third party is not before me. So my limit, the limit of my power is only for the parties. So if, for instance, Kemi has those documents in her possession, I can order her to provide for them. However, if it's a third party, I can't. If she says that it's not with me, it's with the bank. That's the limit to my jurisdiction. But now, even though the act says that the new bill rather is proposing, there's also still going to be a limit. We can't compel third parties because they're not before us. So there's still some things that will still have to go to court. We didn't go into those details, but there's some powers that an arbitrator would never have. I can't compel a third party, I can't compel a witness. But even if I do, there's no point giving me a power that I cannot use. I cannot enforce. So if I compel a third party and the third party doesn't come, what can I do? So that is the limit. And that is why at times, unfortunately, we still need the assistance of the court, especially when it has to do with interim measures. Because there's a limit to what an arbitrator can legally do. Yes. Okay, so the arbitration agreement is not an agreement as in 10 pages. It's just your clause. So that clause is is the arbitration agreement. Let's assume now that you and Bernard went into a contract. Eventually, there was a dispute, but the contract, for whatever reason, has been terminated. That clause is such that it's separate from the agreement, and you can sue upon it. That's why it's separate, and I said it's talking of separability. It's separate from the underlying contract because you can sue upon it, even though that you've terminated, but there's still some issues. So you can use that as your basis to go to court. I mean, to go to the arbitration. Exactly.
So with the arbitration in that scenario, there's a tenancy issue, and the arbitration clause stated that the party should submit to arbitration during the subsequent of the tenant. Then tenant got to be 25 years, and now the landlord wants to evict the tenant and so the tenant to court. But tenant saying we have an arbitration to go to arbitration.
And what did the court hold?
I think the court held that that's
Eviction is different, unfortunately, we all know, but the truth is that once there's an arbitration agreement, they can come to arbitration. But we have a scenario, and there's section 5 and I think section 6, no, section 4 and 5 about stay in the Arbitration and Conciliation Act. And at times it's difficult, where it says that where there is an arbitration clause and you go to court, the court should stay. And it also goes on to say in another subsection that in the event that you now come to the you continue, the arbitration rather can actually continue some. So it's been a bone of contention, but the new bill has actually resolved all that. But the truth is that once there's an arbitration clause, the court should not ordinarily meddle into arbitration. And that's why we've been training judges, because at times some judges do not understand that your arbitration clause deters them and they should not touch it. But a lot of judges now understand arbitration, what arbitration is about. And once they see that there's an arbitration clause, they tend to always shy away.
Okay, I just want to make a comment and maybe a question. The award review tribunal.
We didn't ask the people online.
So after event, we're going to go online.
Okay.
The award review tribunal, it seems to me like removes the finality to the award of the arbitration tribunal?
I think it's too early to say. The award review tribunal, it's supposed to not to, because the idea is that there's a time limit within which the award review tribunal has to render its decision. So if you look at it from that point of view, if you wanted to go to court, even your filing before you're heard, it takes time. So for me, it's a welcome development. We can only see how it goes if there are loopholes. And I believe that is work in progress. But at the moment, a lot of people are happy with that development. Because at times, setting aside takes years. And this one has a time limit, maybe 3 months or so. So thank you.
All right, I'd like to invite online participants to ask their questions. If you have a question, kindly unmute your mic. Please introduce yourself and ask your question. Babani first, do you have a question? Okay, please go ahead.
Yes, I do. Good morning, everyone. Good morning, Ms. Folashade. I am Babani Fesajit. Very well, ma'am. It caught my mind when we were talking about consolidation of arbitration. And I was wondering what happens to the constitution of the tribunal when two arbitrations are consolidated. It's easier for me to think about the joinder. I mean, the arbitrator continues to work on the matter, but when two different arbitrations, what if the tribunal in one was just an arbitrator and another was 3 arbitrators? What happens to the constitution of the tribunal when arbitrations are consolidated? Thank you.
Consolidation is very complicated and there are rules attached. You can't just consolidate any disputes. The parties must be the same, it must arise from the same decision. So it's not, and obviously there will be the issue of submission agreement, because if I was initially appointed to deal with A, the 2 parties are saying that, but we also have another issue. I cannot handle it until they both submit. So consolidation can only, there's still limits to what you can consolidate and who you can join. I can't join a 3rd party except the other party agrees to. So there are rules attached to it. It's not as straightforward as in you can just consolidate or join any party. And normally, joinder will be the same parties, but maybe an adjoining matter. So if, for instance, now we're suing regarding this room, and the next room for ICC is also part of it, and you're not asking them, Mrs. Ali, you understand, but your contract, I can't, even if it's within NECA, I can't just decide that I want to preside over that dispute, except the parties agree, and I'll insist that they sign a submission agreement, asking me that I should also add that issue as an additional issue.
All right, I think we have more people in the room.
Don't worry, keep asking.
It's not a question, what you said, my girls will go back to the question you asked earlier. Probably there's a third party that will be affected by your judgment. I think as an arbitrator, you should be, law has just given you the power to ask that third party be joined.
I can't just join someone except the other party agrees. Okay. That is why arbitration. You can, but the parties must agree. I'm an arbitrator. My scope of jurisdiction is determined by parties, and I cannot impose myself on the parties. So if you want me to join the parties must agree. So that 3rd party that they want to join, Kemi must agree, Bernard must agree.
I'd like to find out what to do in a situation where you have a plenary award, which states that a bank wouldn't justify the transaction against the customer. However, the arbiter got his full fee and closed at that stage. Later on, we found out that the arbiter sat again in the absence of the customer and granted an award in favor of the bank against the customer, regardless of the preliminary award that was initially awarded. In that circumstance, what do you do?
I'm not sure I understand that question.
Okay.
There was a partial award.
Yes.
And then of the same parties.
Yes.
The arbitrator now went ahead to hear one party alone.
Exactly.
It's not possible.
I experienced the situation.
Is it that the other party was not aware or the cause?
Was not notified.
It's not possible. Then it's grounds for set aside. Period.
Okay.
All right, we're going to have a few more questions so that we can wrap up.
Someone has a question from here.
All right, good day, everyone. Thank you very much, Freda. So, in this age of ChatGPT, AI, we have some companies who assume that they can draft agreements by themselves, and for instance, they go ahead and draft an agreement. For example, maybe it's just a 2 million naira worth of transaction, and they now put in the dispute resolution clause after. What's better of what they see, or probably copy from somewhere. They put in that, okay, when there's a dispute, they would have 3 arbitrators. So yet the dispute arises, and of course, appointing even just one arbitrator is not, like the cost of the transaction already is so ridiculous that just even 3 arbitrators cannot. So in this kind of instance, what's the way forward? Where they actually can go forward by going to court.
When did you join us from beginning?
No, I came in.
Okay. So I'd addressed that before. It's called the submission agreement. If both of you know that 3-man panel will be too expensive, you both agree to one, and then you sign something called the submission agreement. I actually showed a sample where the parties will now say that whereas the dispute has arisen, we have now clause this said 3, we now submit to the appointment of 1. It's called a submission agreement. You're welcome.
If you're online, please.
And also there's something called online arbitration, which is called ODR, which is the norm now. So the arbitrators, that's the specialty is just to do online arbitration for small disputes.
If you're online, please, we're coming there shortly. We'll just have 1 or 2 questions from the room. Then the last few questions will come from the online participants. Thank you.
Thank you very much, Mark, for the lecture. I'm listening keen and really have been, I can say I've been legally blessed from the whole lecture. I just want to bring us to our current realities. When arbitration became more pronounced recently, especially lawyers were fascinated by it because of the rigor and stress that we have gone through in court. And theoretically, when we are all discussing arbitration in trainings and possibly in law school and university, they teach us about these advantages, which are very much reiterated today, the privacy, confidentiality, flexibility, and all that. To me, right now, practically, there seems to be a discord between what arbitration should be and what arbitration is. Because if I can, off the top of my head, for instance, the Sunrise arbitration, it famously, how do I put it? It famously ridiculed every advantage of arbitration. I mean, it was not private, it took a lot of time, there was so much documentation and all that.
The Mambila one? The Mambila one?
Yes. So how do arbitration proceed from here? Because arbitration is meant to be like a succor. It's supposed to be something other than litigation.
Thank you. Good question. There's a reality. That's why a lot of people are finding arbitration. It's international. So there's nothing you can do, which is why I said we can talk about privacy, flexibility for domestic, where the sums are not large. But when you're talking about international, every step is no longer, once it has to do with nations, countries, it's really not private. Investor states arbitration is slightly different, which is the level you're going. There's nothing you can do. The instances, even the ICC ones, are not really as private as it should be. But what they always ask parties is that can they publish after? So you can see a lot of awards that has been issued by various arbitral tribunal online because parties actually consent. It's just more how many would not? So the percentage has shown that most people would not, we don't have an issue with it being published. The only thing is you can't use it as precedent as you do for law cases, because they're not binding on any other person but the parties. But honestly, your point is valid, but there's nothing you can do. It's just that arbitration has taken another level. It's become more acceptable to business-minded people. And unfortunately, because of the popularity, people are hearing more and are knowing more about it. And if you can resolve your dispute in 1 year or less, why go to court for 4? Publication, unfortunately, is just the reality. ICC, a few others. Even when I write mine, I say it's private, but the parties would show 1 or 2 people. So, and when you have third-party funders, it's becoming more and more. That's why I said that the reality is that it's not as private as it used to be. But those were the fundamentals that we all learned, and that's how it's supposed to be, but that is not how it is. Thank you.
Thank you so much. Our owner viewers, any more questions from your community? Okay, no more questions. Right.
Thank you, everybody.
Thank you very much, Maria.
Thank you, everyone. And I wish you all the best in your career as you pursue to become arbitrator. It is possible. Don't give up when you don't get appointments. It never happens in 1 day. What you should do is what I...
Someone is raising their hand from the online community. Please, how can one join the institute?
Yeah, that's where I was going. So basically, I'm a member of, hello. So for me, I always encourage everyone. If I tell you that I started arbitration when I was like 45, so or 40 or something. So I didn't give up, and I didn't get appointments. I did all the courses, still didn't work. What I did was I started attending meetings, I started volunteering. They have conferences, you put your name out. So you just keep trying. And it's unbelievable, somebody will believe in you after a while. So just volunteer, never ask for money. Just keep volunteering that you want to be. Can I be your registrar? Or do you mind if I just come into looking? And some parties will agree, some will not. And after a while, you would get there, but you need to be visible, you need to be seen. You need to be seen to know what you are doing. Join the institutes. I joined Chartered Institute of Arbitrators, the UK branch, the UK Nigerian branch. There's now so many. I cannot tell you that anyone is better. I never say so. There's Nigerian Institute of Chartered NICAB. They're fighting us. There's good. There's ICC, is international. There's regional, there's so many in Abuja. My advice is don't join all, because you just be jack of all trades. You never know anything. Just decide on which one you prefer. Stay there, be focused, do the courses, show that you are committed. Somebody will see you. So it doesn't happen in 1 day. And don't give up. I think probably for over 10 years, I didn't get 1 appointment. And I kept complaining. I'll go to Mrs. Arabalogun's, Yekunle, that nobody's, I'll give up. But when it starts coming, it just rolls in. But it won't happen in 1 day. So please, if you know, life is always, everybody has a story. But the story is that believe in yourself and believe you can do it, but you need to know your work. You need to know your stuff. You can't say you want to be an arbitrator and just think that, oh, Joe Block was appointed and he didn't do the course, so I don't need to. There was a time I didn't get, I can remember I went to do my own award writing exam in England. They were doing it here. Somebody said to me that, but why are you wasting? I said, because I want to be the best. So I didn't say that they were not teaching, because then we're not teaching it. Now we're very, very good. 10, 15 years ago, we're not. I went, I did my exam. I scored 98%. It didn't come in one day. I read as I was going to die. Everybody else didn't read, but I was trying to make a mark. So today, I'm a member of the Professional Conduct Committee of the whole of Chartered Institute UK, not Nigeria. So basically, when there's any allegation of misconduct against anyone, we oversee it. It didn't come in one day. You understand? So you need to put yourself out. Volunteer. It always works. Money won't come in one day. I know you say it's difficult. I know you say you don't have money to attend conferences. Put yourself out. Somebody will sponsor you. But if I don't know you, how do I sponsor? So my message is, everyone, arbitration is being flooded. Too many lawyers, too many judges. Everybody now thinks arbitration is the way to go. So it's not as easy as we say. Even we are having difficulties. But what I'm trying to tell you is that if you put your mind at it, you're so young, you will get there. If I can get there at 60, you can get there.